So again, welcome. If you didn't hear me say that the first time, I'm so glad you're here. I love presenting and helping people understand law can be a technical thing, it can be a boring thing, it can be a lot of things, but if you don't know anything about it, it can be an intimidating thing. So helping you understand is really an honor and a joy for me. So tonight we're talking about trust. It's one of the most common questions I get. I'm going to focus on the question this way. What trust is right for you, revocable or irrevocable? That is overly simplified, and you'll understand that why before we get done tonight. But we are going to be focusing on that distinction, the basics of all trust and how that applies to you and what you should be thinking about if you are considering a trust in any way. You'll see some information there on the screen. Elder Law Guidance is my law firm. And the house that is sort of behind the graphic there is the main office on Main Street in Richmond, Kentucky. I am an elder law attorney out of Richmond, licensed in the state of Kentucky. And what I'm going to do as I present tonight is give you Kentucky law. There is a fair amount of what I'm saying that applies in any state. It's federally regulated, but for the most part, you need to take away this concern that all law is going to be state specific. So when I'm talking tonight, I don't take me to be giving you legal advice. I'm giving you education and general guidelines. Nothing I say as persuasive as it may sound, and as definitive as it may sound, is something that you should take as advice. Go apply it, because there is no substitute for talking to an attorney one-on-one about your very specific concerns. Somebody's already asked, do I have an office in Louisville? No, I don't. Kentucky Elder Law is a friend of mine. There's about 5 attorneys in that firm in Louisville. It is the largest elder law firm in the state. I am the 3rd largest elder law firm. There is a second largest is in Lexington, and we're here in Richmond with 2 separate offices here. Move to that next slide. So the purpose again is to educate. The main thing I want you to know is that I am here for you. I will be as specific as possible, but I can only give you specific answers if you talk to me about it. So since I already told you I'm concerned about confidentiality, I'm going to speak in generic terms. If you, for instance, if any of you were a client of mine, I'm going to act like I've never met you before. That is to protect you. I'm not being snooty. But if you do unmute, you give me a specific scenario, I will try to address that question directly, because I want this to be as helpful for you as possible. It may be that I tell you during that process, I think this is something that we probably ought to schedule a consultation for. Our consultations here are free. You can come see if this is something that we can really help you with to get some clearer direction. So emailing, calling, texting are really important ways to get more specific answers for you. Now, a little bit about me first. I am a military veteran, served 5 years in the U.S. Army as an air traffic controller. This is a second career for me. I've been in the practice, well, in law since 2010. So 15 years now is when I started this direction. Before that, I was a Protestant minister for nearly 20 years. And I have a whole lot of overlapping business experience of things that have really formed the way I built the practice and the way I practice law. The choice to go into elder law has a lot to do with that transition I made when I was doing church work, did a lot of work with people in funerals, a lot of hospital visitation, watching families go through that. And when that choice to move away from ministry to law happened, I wanted to make sure I could help people in those specific kinds of life circumstances. I wanted to build on those experiences. So I've been dealing with death and dying in that sort of context since 1991. But when I finished law school, I knew I wanted to do just this. Immediately sought to work with the elder law section, specifically in elder law. I don't do anything else. I can't help you with a divorce. I can't help you with a speeding ticket. All I do is this. So I'm well accredited, work with national groups like NALA or Wealth Council or APAC, a number of organizations like that. So Although I'm talking about Kentucky law, I can help you. And I see somebody asked about Indiana. I can make sure that you get a solid referral to Indiana. Depends upon the area of the state, and I can give you some more direction as we get down the presentation tonight. The other thing is I'm very much into historic presentation or preservation. So you see a couple of the houses that I've restored here in Richmond. Those are only two of the four, maybe five, depending on the age that you consider the other one. So that preserving history and giving back to the community is something I care a lot about. I might be the beauty in the outfit, but I'm definitely not the brains. There's a lot of wonderfully smart, talented, very skilled people, other attorneys on staff that work for me, hands-on legal assistants that work to make sure if you are working with us that you're getting the attention and guidance that you need. We focus on Medicaid long-term care planning, VA benefits planning, guardianship, estate planning, and probate. That's really what we're focused on. So, with those things said, let's talk trusts. All kinds of trusts. People ask the question of me often, can you tell me about trusts? No, I can't tell you about trusts. That's like saying, can you tell me about animals? There are so many different kinds that you have to have some sort of qualifier to narrow that conversation. This gives us a little bit of an idea of some of the kinds that we're talking about. So, a guess, how many types of trusts are there? Well, when I started the practice, I actually went and tried to count that myself, and I got up to 138. And I'm not sure that that's all the different types, but that's the number that I was able to ascertain. People think that this is a very simple thing. You go to a book, there it is. That's not the way it works. A trust is really just a contract, and it's a contract that governs anything that we choose it to cover. It could cover land. It could cover a pet. It could cover insurance policy. It could cover a second rental property. It could cover just a set aside bank account to qualify for a particular benefit. So, the number one thing when we're talking about trust and trying to understand them is you understand that number one, it's a contract. And what's most important is first asking, what is the goal I'm trying to accomplish? That's what determines the type of trust. So, just as an example, there's all kinds of fairly common trusts that you may have heard of. You may have heard of a funeral trust. You may have heard of a pet trust, a gun trust, an ILET is a life insurance policy. A CUPERT is a qualified personal residence trust, which is really for vacation second properties for the most part, but not always. A QTIP, a qualified terminal interest. Those function more in blended families where you're trying to set aside for a surviving spouse versus the bloodline children. So my wife and I, she has children from a previous marriage, as do I, but no children together. So we want to make sure she's protected, but also have things go to my children. That's what a QTIP does. Charitable donation trusts can work in forward-looking and backward-looking ways. So that's what grants are. Those are trusts that retain annuities or make sure that a current asset is paying to a charity, whether paying now and then going to return back to the family, or whether it stays with the family now and goes to a charity later. These are types of trusts. Perhaps one of the more common, if you're an infomercial kind of person, Susie Orman, Dave Ramsey pushes these things a lot too. Revocable living trusts. If you listen to them, you would think that's the only kind there is, and that's not at all true. Intentionally defected trusts are what I do a lot in, and those are really functional for tax lowering while performing asset protection. So asset protection trusts are a digit. There are also various types of asset protection trusts. So asset protection for small estates or asset protection for large estates. So for instance, if I had a very large successful company, let's say 20, $30 million, and I wanted to make sure that if I got sued, no matter what, that money would go offshore and I could never be to liquidate the business to pay out some sort of a settlement. That's a very sophisticated type of asset protection trust that's different from, hey, how do I make sure I qualify for Medicaid benefits? But they're both referred to as asset protection. There are also Medicaid compliant trusts, which have nothing to do with asset protection. So that's another reason people get confused. Qualifying income trust is required for Medicaid long-term care benefits if you have income over $2,900 a month. Those are often referred to as Miller Trust, spousal lifetime. You get the picture, right? There's lots of them. These are common types, even though there's at least 138 that I've counted. So let's get rid of another problem. When we talk about trust, there's all kinds of myths about the things. Number one is that myths are only for the wealthy. Well, some of these trusts have nothing to do with wealth at all. I want to protect, set aside some money for a pet, or make sure that a gun is not lost to the government. For instance, I have a silencer for a Target 22. That silencer cannot be passed on as inheritance unless it's in a trust. Weapons could, and gun trusts have sort of fallen out of favor because they can be expensive to operate, but trusts have nothing to do with wealth. They can protect families of all income levels. And in fact, I do lots of trusts for people on SSI. And SSI basically requires that my income is less than $1,000 a month and I have no more than $2,000 to my name, but they still must have a trust in order to not lose their benefits if they inherit any money from their family. So, absolute myth that they're only for the wealthy. Another myth is that a trust, or sorry, that a will is good enough to protect me. I'm going to say some things here as we go through this presentation tonight about probate and wills. Now, both a will and probate are really important, often necessary things. As a matter of fact, everyone needs a will. Even if you had three, four, five different kinds of trusts, you still need a will. However, the problem with a will is that a will can be thrown out or elected against by your spouse. That's a very concept. So let me go ahead and explain it now, even though we're just talking about 3 points on this slide. Let me create an example here. My wife and I are married, and as I already told you, I have children that are not biologically my wife's children. I also have 2 houses. We have a house we live in, and this house, for instance, that we run the law firm out of. We have an apartment and live in this house at times too. Excuse me. But let's say that the farmhouse that we live in, I absolutely, if I pass away, want my wife to get that. But I want my children to get something. So let's say that I give the office house to my children, and that's what I put in my will. Once I pass away, however, my wife can say, "Phooey on that. I like the office house, that magnificent Victorian historic home. I want that. I don't want this farmhouse." And she can elect against my will. So that basically means she throws out that provision, and then she gets 50% of everything, regardless of what I said she could have or my children could have. And then that creates all kinds of problems because my children may not be able to purchase the 50% value from her so that they could get anything. And we've all seen examples of this where families go into probate and then the house just sits there vacant for, I remember as a child, I watched one for 20 years. Never was sold because it was tied up in probate. The family was fighting and no one had enough money to buy the other party out. So your will is not airtight. Your spouse can choose to go against your wishes in the will. And you may say, well, that would never happen. Well, it may not happen, but you never know. Um, a will is enough to avoid probate. No, it's not. A will, in fact, necessitates probate or it's not valid at all. A will has no binding effect during your lifetime. It's just stating what you want to have happen once you pass away. And the government, the court, no one will follow it unless you go through probate. Another myth is that trusts are too expensive. Honestly, trusts are no more expensive than the probate process in most circumstances. It's going to cost you more to go through probate with your will than it would to have a trust and avoid probate. So Lots of things there that sometimes we just have heard horror stories, whatever, and we think, trusts are too crazy. I don't want to get involved in that. But what does force a lot of people's choice in whether they want or need a trust is probate itself. Now, probate can be a very important thing. What probate is once a person has passed away, the court makes a decision as to whom receives my stuff once I'm passed. Now, if I have a will and it's determined that the will is effective, valid, met all the criteria to be a valid will, then that's what the court's going to follow unless the spouse elects against it. That process then is the court making sure that whoever is in charge follows what my will says. Now, if I don't have a will, probate is going to follow state law, and government determines who gets my stuff. That's why you need a will. But if you have a trust and everything you own is in the trust, you can avoid probate. And sometimes people really want to do that. So why? Well, first off, the probate process is on average, it's required to last at least 6 months, but on average will last something in the neighborhood of 12 to 18 months, sometimes even up to 24 months. And it can cost three, four, five, up to $7,000 for the average estate. Is public. All the records get to be uh, they're available to anyone that wants to look at them. And a lot of folks just don't want everybody knowing how much money they have, what kind of wealth is passed on, who got what, especially if there's tensions within the family. Now you've got these people knowing I gave stuff to a cousin or a neighbor or whomever, and people just don't like that. Whereas the alternative, a trust-based estate plan, you can be through with that in just a matter of weeks. It's completely private. No one has to know what's going on. The only people involved is the family. And in fact, the trustee is the only one that really is involved in all that stuff. No one else is overseeing it. And there's no cost. In fact, you don't even have to go to court. You don't have to go to a lawyer. You could technically do this completely on your own with no cost whatsoever. So big differences there. Now, I'm going to pause for just a second, everyone, and I want to see if I can look at these questions and determine if any of them need to be answered at this point. I think I've dealt with the difference between will and a trust, at least partially so far. Dealt with some of the probate costs versus setting up a trust in general. And the public attend court when you're going through probate. Not only can they, will. Go to probate court nearly every week. When in there, there's going to be 30 to 50 people every single time the door is open. Depending upon the size of the county, it could be 60. The other counties, there's just 12, 15 people there. But everybody listens. There's no closed door. Anybody waiting on the criminal docket is there. Everyone hears what's going on. Asking if CDs who have a listed beneficiary have to go through probate. Under most cases, no, they do not. Anything you have with a named beneficiary, like a life insurance, a CD, if you have rights of survivorship on a house, those things avoid probate. But there are circumstances where that can backfire on you. What most common is sometimes we just forget about one, or the beneficiary passes away. Would then require them to come back into probate, even though generally speaking, they're a non-probate asset. Have I heard of AI generated trust? I've heard of AI generated everything so far, and I want to talk about that. Let me talk about that right now. Let me see what's our next slide. Problem that we're facing in the world with the emergence of technology. You can go online and you can, a will, for instance, I'll give you an example. You can pull down off the internet a last will and testament tonight, fill it out, or you can come to my office and we will do a will for you. Our will is going to cost 2 to 3 times more. And lots of people, therefore, try to do it themselves. They'll do wills, they'll do trusts, they'll do powers of attorney. At least 70% of every client that hires me already has one of those things, and it's wrong. Now, how do you know the one that you downloaded and executed, or even went to a general practice attorney and got, is right or wrong and is going to hold up. You don't, because you're not a lawyer. So it does baffle me why we understand we're not going to go to a dentist to have brain surgery, but we think we're going to go to a computer software program to get specialist information. So I beg you, and anyone knows me, ask around, ask about my reputation. I'm an honest person, and I'm going to tell you if there's a cheaper way to do it. I'm going to tell you when you don't need me. But I can tell you that one of the mantras I live by in my practice is that I am going to be more cost effective than the problem it's going to create if you don't hire me. Believe in that so deeply. So yes, you can get AI generated trusts, but what it requires for you, back to the very beginning, a trust, you have to first determine what your goal is. So you're telling the AI software, create me a trust that does blank. So who's the expert? You are. And a long time ago in law school, they said a fool is their own attorney. You're pretending to be your own attorney, but you don't have any insight to do that. Now, I'm not trying to be a smart aleck here, but I think as you go through tonight, you'll hear a few things. Oh, I wouldn't have known that. As a matter of fact, I'll make it clearer with this point. I have around 400 clients that hire my law firm every single year. And of those clients, many of them have wills that I created, but about half of them have wills they received somewhere else from another attorney. I have never in my life seen a will that includes the provisions that are under IRS code that allow a spouse to receive everything as an inheritance without it being counted against them for long-term care calculations. So if I inherit $200,000, the government says, oh, well, now you have $200,000. If you write the will the right way, the government says, I don't even see that $200,000. It doesn't exist. Those wills, not having that essential provision, were created by licensed attorneys that were not specialists in the field of estate planning. So you must go to a specialist. You're going to get what you pay for. Oftentimes, it's going to realize that it was a defective, a not high quality thing that you got, whether it's a power of attorney, will, or a trust, only after it's too late. I really caution against that thing, but that you have the right to do whatever you want. But it's very, very dangerous. And I spend so much time with clients who've got poorly estate planning documents. Okay. Many of these things are going to come up. Bank accounts with POD, avoid, probate, and the rest of them are going to help I go through the presentation. So, okay. What are the benefits of the trust? I already talked about the limits of a will, benefits of a trust. Well, the trust cannot be elected against. There's no way your wishes are going to be followed 100%, cannot stop. The way that is going to be dealt with. Be very specific in your distributions. Now, you can be just very specific in a will too, but if the will can be overturned, what difference does it make? So, what I'm meaning here is if you have, let's say, I have 12 grandchildren, and if I want to give them all money, I can make provisions in it that I can say each of my grandchildren get whatever, let's say $5,000 each, but they cannot get it at age 18. They must start getting it at age 25. And I want to get it in 3 disbursements, and it has to be used only for these purposes. And I can get as specific as I want to in a trust, whereas in a will, those things, once I die, they're going to be put in place one time, but they're not going to have the enduring effect of continuing to manage that money that I have for those grandchildren. That's what a trust does. Trust is also going to maintain property tax rates. What I'm pointing to here is a lot of times people would take another do-it-yourself approach. And I've even heard attorneys give this absolutely ludicrous, incorrect advice that, oh, just put the children's name on the deed, give the house to the children, and it'll be protected against Medicaid benefits or VA benefits. That's true. Yeah, they're protected, but here's what happens. You lose your homestead exemption that lowers your property tax value by $40,000, so you're paying less taxes. The next thing it does is it gives away your capital gains exclusion of $250,000. So when the children go to sell that house on down the road, they're going to be hit with a 15% capital gain, perhaps even a 20% capital gain on that property. And that may end up being 60, 70, $100,000 worth of taxes due because we tried to use this do-it-yourself approach instead of using a trust where all of that tax is avoided. Now you do the math. Trust costs you a couple $1,000. The taxes by not using a trust cost you $60,000. Which one would you rather have? And I've had that conversation with folks that say, I don't care. I'm dead at that point. Okay, valid point, but still the cost is the cost, right? So you can do tax lowering options with trusts. That's another option here. It ensures privacy. It protects against creditors. These are all benefits of a trust. They also, even if you don't have any of these pressing problems, the trust helps you preserve options for yourself that you would not have otherwise. Now, this slide is a little confusing because it doesn't that part of this is a myth and part of it is oops, excuse me, I'm trying to get somebody to enter the room and I went too far on my slide. So when I'm talking about these 138 types of trusts, they generally break down into two categories, revocable and irrevocable, like you see here on the slide. Now, I'll talk about those distinctions, but the first thing people think when I start talking about revocable trust or irrevocable trust is they think, oh, revocable, that means we can change it. Irrevocable means it cannot be changed. That's not true. You can change either type. It has nothing to do with what the word says. Irrevocable, I can't revoke it. Yes, you can revoke any trust. The word is a legally technical word that does not mean what you and I mean when we say the same word in regular everyday conversation. The distinction between revocable and irrevocable is who manages the asset. All trusts are managed by the trustee. Revocable trusts, you are your own trustee. Irrevocable trusts, generally speaking, but not always, irrevocable trusts are managed generally by another person, not yourself. So, in other words, I have an irrevocable trust. My daughter manages that trust for me. And if I'm willing to have that offsetted control where my daughter whom I trust as my trustee, then I have these huge exclusions and protections that I cannot get any other way. So that's a tricky little term. Revocable and irrevocable do not mean that they can't be changed or anything like that. Anything can be changed, anything can be revoked. It simply has to do with who is able to be the trustee. And even irrevocable trusts, I can be my own trustee in many circumstances. However, revocable trusts, especially living trusts, often referred to as RLTs, revocable living trusts. RLTs, the main benefit of them is they are very flexible. When I put things into an RLT, that type of trust functions as I always have. I write my checks, I put my money in these accounts. Nothing is different except the name on the account. Instead of it being Scott's checking account, it now becomes Scott's RLT account. But everything else remains the same. I still have debit cards, I still write checks, I still make deposits, I invest everything the same way. Nothing changes about the accounts held in that trust. So that provides me a lot of flexibility. I get the protections that the RLT is giving, and I didn't have to really do anything. I didn't alter my life at all. I still have my Edward Jones investment. I still have my vacation property, and my minivan is still in there. Whatever I've got. In fact, a surfboard could be in there. Who knows? Very flexible. Whereas the benefit of an irrevocable trust is that it gets all of those things out of my name because I'm not the one who is the trustee. And therefore, it gives me other protections and benefits like I'm trying to apply for long-term care coverage and I've got $1 million in a trust. The government says, no, you don't have $1 million because that's in your trust. It belongs to your trust. It doesn't count against me. Similarly, if I were sued, a lawsuit, that stuff's in my trust. I can't be sued. They can only sue me for what's still in my name. Now, if you had an RLT, could you be sued? Yes. Irrevocable? No. So a different level of protection, huge difference in benefit there. The main drawback that you can see at that next level is you are giving up control in a sense because you have to go to the trustee and the trustee accesses the money for you. The money is still there for you. It's not locked down that you can't use it, but you don't go to the bank and write your own checks anymore. In most cases, there are exceptions, but that's the main difference between you still operating a revocable, trustees operating the other one for you. So what do we use these things for? To avoid the weaknesses of a will, to reduce estate taxes. I'll talk a little bit more about that in just a moment. To protect from creditors, and also to guarantee that healthcare benefits like long-term care is available to me, or to qualify for VA benefits for that matter. Now, this slide's a little bit repetitive, so I'm going to skip a little bit, but you can see there, a will must go through probate. Trust doesn't have to. A will, does it control anything? Nope. Will has no binding effect until after I'm dead, but the trust is effective the moment I put it into place. So it gives me a lot more security that way. Asset protection, will doesn't help me a bit. Creditors are still going to get paid. I don't have any protection at all, whereas an irrevocable would shield assets, but a revocable trust won't do any asset protection at all. So you can see that there is some distinctions here based upon the type of trust, but vastly more beneficial than just a will. Okay. Let's go to some of the questions before I get deeper into the revocable type of trust. Are the benefits listed pertaining to revocable, irrevocable, or I hope I've clarified that. If I've not, by using this slide and the next two, please write again. I'm talking about real estate. If the property is out of your name, do you still pay property taxes? No, you don't, but somebody else does. And if you've given it to your children, they're going to pay a higher rate than you if you are older than 65. But that's not the biggest tax difference. That just might be a $1,500 cost. The real difference is going to be capital gain. Whenever they go to sell that house, they're going to get hit with a huge capital gain. Can you sell a house if it's in an irrevocable trust? Sure you can. Okay, let's get to the slide. Revocable trust, you can always modify and revoke. There's no limit to those. There are some restrictions on how you modify an irrevocable, but the trustee can do all of those changes for you. That's the one limitation we're talking about. I've covered the prior two slides, so I'm going to get right to this and then let us open it up for all the question and answers that you're going to have. What do you do when you're getting ready to set up a trust? Step one, identify the goal. What am I trying to accomplish here? And once you've decided, here's my goal, then you've got to pick the trustee. Now, the revocable trust might fit this goal, an irrevocable trust might fit that goal. And if it's revocable, you are your own trustee, no choice at all. If it's irrevocable, we have to then choose who's the best fit for the trustee job. Then you fund the trust, and if anything changes along the way, you adapt it. So trusts do need to be maintained over time. It's not a difficult process, but we do check in with clients every 3-4 years, or they come to us when they have a significant life change. But that's how simple that this can be. Again, look forward to seeing you. Give us a call or an email if you need to establish an appointment with us. We'll be happy to help you in any way. And I wish you all the best and look forward to seeing you again soon.